So hello and welcome to this, the penultimate talk in Kent Law School's Summer of Law programme. My name is Darren Weir and I'm a lecturer here at Kent Law School, as well as the director for mooting and mock trials, a very grand title. Don't be afraid by it. I was also a practicing criminal barrister for 12 years before coming to academia, and I'm joined here by my colleague Karen Widess. Karen, tell us about yourself.
Yes, I'm also a lecturer at Kent Law School. Before that, I qualified as a lawyer in another country, you might guess, where I was also a litigator, which means someone who represents clients both in court and out of court on their disputes. And I specialized in civil cases, which is almost anything that isn't criminal. In my case, I worked on property and investment disputes, bankruptcy, general business and banking disputes like contracts and debts and licensing, whatever came in the door with money attached to it.
I see. So you're the money seeker. Yeah. Well, anyway, so between the two of us, you've got here a huge amount of knowledge about crime and civil. So crime and civil represented here today. So as with previous sessions, we'd very much like it if you could join in by making some comments in the chat. The chat, of course, is only seen by us, so you don't need to worry about what you say. You can be completely outrageous, that's fine. And also at certain points, we're going to be asking if you could vote during the debate, during the arguments. And to do that, all you need is a mobile phone. And all you need is a QR reader on your phone. Get that up, hold it to the screen, and then you'll be able to vote. So there's no need to log in or anything like that today. You just need a QR reader on your phone. Okay, well, so today we're talking about how to make a legal argument. And when we think of an argument, we might think in our head something like this. He says, there you go. So we might be thinking about an argument in that way. Well, the word argument, it is defined in the dictionary as an exchange of diverging or opposing views, typically a heated or angry one, or a reason or set of reasons given in support of an idea, action, or theory. So let's just pause here for a moment and think about a more broader question. What is the point of an argument? Okay, so tell us what you think. What is the point of an argument? Put your comments in the chat now. A couple of words. What do you think the point of an argument is? So while you're doing that, Karen will be watching the chat while you put some comments in there. I can see they're coming in now, which is great. And also think about the other types of arguments we have in everyday life. Some pictures there you might recognize. So when we're talking about arguing normally, we always try to be logical, don't we? We want to have a logical argument, and we always think we're right because we're putting forward a logical argument. So next thing to do, so quite a few comments coming through already. Next little project is, what was your last argument about? Did you win? And how did that make you feel? Tell us in the chat now. What was your last argument about? It could have been anything. Absolutely anything. Did you win, and how did that make you feel? So tell us in the chat about that now. So Karen, what do we have so far? What was the answer for the point of an argument? Anyone?
Yeah, I think we had some very good answers. Basically to express your point of view, to persuade someone towards your viewpoint, which is very good, to settle a difference of opinion, sometimes that works. Someone said the aim of an argument is to win.
I like that one. Yeah. Mm-hmm.
Yep. To get your point across.
Yeah.
Or to express your feelings.
Express your feelings. That's an interesting one. Expressing your feelings. Yeah. Okay.
Exactly.
I'm envisaged there. I'm envisaging this huge heated argument. You know, expressing your feelings. You know.
Yes.
Yeah. Throwing
something like that. There was another one that said to get things off your chest.
True.
Sometimes things have to come out. To settle disputes, to explain the reasons behind your beliefs or your actions. I think those are the main ones.
Yeah. Okay, well, let's sum it up. I think, to be honest, the person who's about winning, I think matters, because there's two words. What matters about an argument is to win. That's why you have the argument. Yeah, that is the reason why you want to have the argument, to win your point across. And if you like argument and you like to win, then the law is definitely a field of work for you. But of course, with winning comes the opposite. There will be times when you lose. You don't always win the argument. And so very early on in your legal careers, you're going to have to start building a very thick skin, aren't you, Karen? So that, because ultimately someone's got to lose.
Yes, I mean, and this is an important point, because many of us have entered the law because we actually have argumentative characters. We like to argue, we actually enjoy it, and of course we like to win. And we do have room in the legal profession for those who prefer to resolve disputes by consensus, who maybe aren't so argumentative by nature, but that's a topic for another day. Today we're talking about legal arguments and winning.
But also, even if you do want to deal with the dispute with a resolution, which is more peaceful, like mediation or negotiation, you still need to know whether you can win the argument, right?
Well, absolutely. You need to know what the strength of your position is before you start to negotiate, even if you mean to compromise. However, in the system we're talking about today, we have what's called an adversarial system, as Darren will explain further. But briefly, that means there are always at least two sides to the argument. And the person who makes the decision maker might be the judge or a jury, they're supposed to be neutral. They're not supposed to have an opinion. They're just deciding on the strength of the arguments presented to them. But because of that structure, you are going to find yourself on the losing side. Depending, more often than not, it really depends, but that's okay. As Darren said, it's to be expected. And in fact, it's as important to win as it is to lose well, okay? So what do I mean by losing well? That sounds a bit weird, but it means basically playing the cards you're dealt to the best of your ability. So for example, there may be clear facts in your client's case that go against the client, and there's nothing you can do about it. You may be litigating, disputing under a law that puts you at a disadvantage. And you may realize going in at the beginning, your case is something of a loser. So losing well means to get the best result you can. You still make the best arguments. You still present the strongest case. And a good result might be keeping your obviously guilty client out of jail. It may be reducing the jail sentence she's subject to, maybe reducing the amount of money damages your client pays their neighbor. Even though technically you've lost, those are all good results in a loser case.
Yeah. So ultimately, this is a skill, how to put together a legal argument, that will be developed in law school, which requires practice, practice, practice. And even we as seasoned practitioners are still learning. So as you heard, the context of a legal argument is within the adversarial system, which means that you will have two sides of a case, each of whom are responsible for presenting their point of view or their evidence or their legal point in an effort to win. So perhaps when it comes to a legal argument, the definition of argument should be perhaps narrowed to this. The point of a legal argument is to convince someone in a position of power to make a decision in your favour. And what of logic? We talked about earlier how when we argue normally, the logical argument normally always wins. Well, sometimes a logical argument in a legal context, and a legal argument will win the day, but it was in fact an American jurist, Oliver Wendell Holmes, who famously said, the life of the law has not been logic, it has been experience. And by that, really, what we mean is that sometimes the results you get in it as a result of a legal argument may not be logical. And that's because law looks at the experience of humanity, the experience of life to make decisions. And that's where the expression, the law is an ass, comes from. Because sometimes the law, people will look at a decision and think that doesn't make logical sense, but legally it makes perfect sense. So thus begun the revolution of how lawyers and judges interpret the law and the way you as law students will learn the law. So where does this sit into your study as a law student? Well, every law module that will be taught to you will teach you about arguing law. Every law module will assess you on your ability to argue both sides of an argument. You will need to study lots of case decisions to see how each side presented their argument and adapt and adopt the best arguments for your conclusions. And there are also certainly at Kent and in other law schools, there are specific law modules and co-curricular activities such as mooting that focus on legal argument. So the study of law is not a science. Rules of law do not describe objective truth, they reflect subjective intention. So your job as a law student isn't to deduce the law from a set of principles. We would be failing in our duty to teach you how to put together a legal argument if you just did that. What you need to do is actually look at the sources and the conflicting values in the law to come to certain conclusions. And it's this aspect that hopefully you'll find quite rewarding and challenging. And that's where our critical legal education goes beyond the legal principles, because we challenge, ask questions about the larger socio-political, economical circumstances surrounding the legal decisions that are made. So when it comes to legal arguments, you cannot just argue any old thing. It can't be like your last argument. So are there any examples, Karen, of the last arguments that people have?
There are. Someone said that they argued about what to watch on television. That's a common argument, at least in my house. Someone else said it made me feel powerful because my arguments were good and I made the person understand what I was thinking, which is a very good result. Another person said they were arguing perhaps about, they had a frustrating argument about Black Lives Matter. And we can think about scenarios that would lead to frustration, particularly if the opposing person is not convinced. And some people just said, I won or I lost.
Yeah. So what I'm sensing there is there's a lot of personal preferences coming through, aren't there, Karen? So when it comes to legal arguments, you can't argue your own personal preference and opinion. So for example, you can't argue, I think that X is a better decision. Why can't we just argue that? Why can't we put forward arguments like that in a legal context?
Right. I mean, we're looking for an objective standard. So if you say, I think this is better, it's just a personal preference. It's the same thing as saying, I like this better than I like the other. And it's solely subjective. It depends on your taste, which can be very different from person to person. If I say I like blue better than green, that's my preference. But it doesn't really make blue a prettier color than green. It's just a subjective view that I have. And so when we make a legal argument, we're striving to prevail under an objective standard, which does not vary between people very much, or at least not in any way that really matters.
So, okay, so if I were to argue that X is the correct answer because it is fair, objectively more fairer, is that the correct way to go about an argument?
Well, it can be if everyone has the same understanding and accepts the same meaning of fairness in a particular context, then we can consider it an objective standard. But having the same understanding is not always easy. If I give you a brief example, in this country, we believe it's fair that we pay for our system of medical care through our taxes, and everyone has free access without having to shell directly out of their pocket. And so everybody pays for everybody, whether they actually need medical care or not. And we consider that fair. That's the NHS system. But in other countries, they don't think it's fair to make all taxpayers pay for the medical care of people who can afford to pay for it themselves. If you need medical care, why should I pay for you? So that's an ongoing debate in a lot of countries. And even though we have a consensus now about what is fair, Circumstances can change. People can change their opinions, and we might lose that common understanding. And what was an objective standard, we all have the same idea about what's fair in the healthcare scenario, can become subjective again. So you have to be careful with that one.
And also, just to take you up on that point, with different tribunals that you might appear in, whether it be criminal or civil cases, for example, the issue of fairness could mean something to one side, but a different thing to the other. So take, for example, in crime, if you want to exclude a piece of evidence, for example, you're representing the defendant, and let's say there was an illegal search. The police, abused their powers, searched on the street and found something in the bag, and you want to argue that was an illegal search and we want to exclude the finding of whatever was found. So the defence would make what's called a Section 78 application under the Police and Criminal Evidence Act to exclude the evidence. And you'd probably say, oh, it's a bit unfair. Look at the way in which it was obtained. Look at the way the defendant was unfairly stopped. He was unfairly searched. It's very unfair, unfair, unfair. But our problem will be that as far as Section 78 is concerned, the test of fairness is actually not fairness to the defendant, but fairness to the proceedings. And therefore the court will look more at the fairness of the case overall rather than the specific rights of the defendant. The answer to the defendant will be, okay, if your rights were affected there, you can sue the police. But just because the search was unfair doesn't mean to say the evidence is unfair to the proceedings. So, from what you were saying, fairness can be a movable feat, which we have to be careful about. Okay, so let's take another example of what if I know I'm right, and like parents, they say to their children, X is X because I told you so. What about that type of position? Is that a fair one?
Well, that's the way decisions are typically made in non-democratic systems. Perhaps like your house, right? Do you ever take a vote every day on what to have for dinner? You just eat what you're given. I said so is actually not a valid legal reason in a democracy, although in authoritarian countries, they use it quite a lot. But in our system, everyone is subject to the same law. The government has to follow the same law and justify what they do. And even your parents have to follow the same law, although not inside their house when it comes to dinner.
Okay, so we've discussed general arguments, we've discussed the sort of context in which legal arguments take place, fairness, objectivity. Let's now look a little more detail, Karen, at the 5 different types of legal argument, which students by the end of their law degree should be able to identify, create, attack, and evaluate these 5 different types of legal arguments. So let's look at these. Here they are. Okay. Talk us through.
Right. So we've talked a little bit about the kinds of arguments that are not acceptable in a formal legal context. And now we're going to talk about the 5 primary ones that are acceptable in a legal context. And we'll go through each of them, and I'll give you an example so we understand. So the first one is textual, which is hard to say, textual. And it has to do with actually the language of perhaps a statute or a regulation that you are litigating under. What does it actually mean? It can be ambiguous. So we can also look at the intent. Whose intent? The intent of the drafter, the people who wrote the legislation. In this country, it's usually Parliament, or it can be a regulation that's made by a specific ministry.
Or it could be a contract, right? A contract
or
between 2
it
people.
Can be a contract. We can talk about the intent of the parties to the contract. So if the text is hard to understand or ambiguous, we can look beneath or behind it and say, what did people mean when they were writing this? Then we have a system of precedent. And I noticed that someone actually mentioned in the chat that we have arguments to establish precedent. This is a very complicated subject to actually go all the way through, but basically what it means is a court will decide according to previous decisions of a higher court. So if the Supreme Court of the UK, now it used to be the Law Lords, now it's the Supreme Court, makes a particular decision about what a word in a statute means, every other case that is decided by any court in the country has to follow that decision. That's what we mean by precedent. And so we look for precedents because we want to see, oh, this looks difficult. We don't really understand this. What have previous courts made of it? So setting that aside. We have a thing of tradition. Because of the way law develops, particularly in a country like the UK, which has a long history and tradition of common law, understanding has developed over centuries about what is permissible, what is impermissible, what a word happens to mean, how we take it. And so we can use tradition to argue our case. It cannot mean that because since the Magna Carta in 1215, it has always meant this. So therefore, this is part of our culture, it's part of our tradition. The last one is policy. Policy is a little bit different. We take a step back and we say, what is the purpose of the statute? Not what does it say? What's the purpose of, for example, we're going to look at a statute about, in the criminal sector, about theft. Why do we care whether the law enforces penalties, criminal penalties, against someone who steals something, right? What is the policy behind that? What is the policy of having all children go to school up until the age of 17 or 18, right? It used to be that people left school earlier, 15 or 16, right? Along the way, the policy changed because the government wanted to achieve a certain thing. It wanted to achieve a higher level of education in the general population. And in order to do that, we better make a law that says everybody has to go to school until they're 17 or 18. So that's the policy behind it. And you can argue that, in fact, the law as it stands doesn't fulfill the correct policy, and therefore the law is invalid. And that's a good argument. So let's start quickly. This one is textual. This is going to take me a few minutes to go through this, so bear with me. Okay, so we actually have a statute, right? This is the Theft Act of 1968, and it basically says a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. Now, if you can show that your client never intended to permanently deprive the other person, maybe they borrowed it and actually gave it back, right? They borrowed someone's book, they borrowed someone's car, and they gave it back, but they've been charged with theft. On the face of the statute, right, you have to prove all these things that are in bold. You haven't succeeded because you haven't fulfilled proof for the statute of intention to permanently deprive. I have really good evidence to show that was not your intention. Okay, so this is what we do with textual. Now, a lot of times, particularly in contract law, it's not clear from the text what is actually agreed to. It works in criminal law as well as civil law, such as contract. And therefore, again, if we look at this definition of theft, the statute, and we're looking at intent, whose intent? It is the intent of the legislature, in our case, Parliament, who drafted the Theft Act, okay? And the presumption is that Parliament, well, there are two really presumptions, that Parliament intended what it wrote, that it wanted to make it quite difficult to convict somebody of theft because you have to show dishonesty, which is a state of mind, that's difficult to prove. You have to show intention, which again is a state of mind, is difficult to prove. But the legislature didn't want to leave those out. If it had drafted the text that said, someone is guilty of theft if they take someone else's property, which is kind of how we think of it informally, that's too easy. That is going to rope in too many innocent people into being convicted of the crime of theft. So Parliament intended that this be a rather difficult burden for the prosecution to meet. There's also compromise. So often we don't know what a statute means on its face because it's controversial. And in order to actually get it through Parliament, they sort of massage the language and they make it a little bit less than clear so everybody can agree. Remember, we were talking about subjective and objective. They're not trying to make everybody agree exactly because it would never get through and we would never have a law on it. So when we look at intent, we want to know what people were thinking, what the legislators, what the drafters were thinking. And depending on if you're in a criminal case or a civil case, if you're using a statute or a contract, you look at different kinds of evidence to discover intent. Next. Precedent. I mentioned precedent before, and without going into a long description, all of these words that are in bold from this theft statute have been disputed, usually by the lawyer, the counsel, the barrister for a criminal defendant, by saying, well, yes, but what my client did does not meet the definition of dishonesty. What my client did does not meet the definition of appropriation, right? These are not obvious. What my client took wasn't actually property, right? It was something else that didn't belong to anyone. He picked it up on the sidewalk, he found it, it's nobody's property. Those things come to court, and courts make a decision about whether in these circumstances what this client did meets the definition or not. And usually there's an explanation in the case that says, by dishonesty, here's what we mean. And they may use different kinds of arguments: tradition, intent. Here's how we've understood dishonesty from the beginning of time in this country, right? Which is usually somewhere around the year 1179 for some odd reason, which you'll get to when you study property. You can do that. You can make that argument with everything you approach. Has it been tested in a court? Can you find a prior decision that maybe is not exactly what we call on point, but is influential? It makes sense to apply it to this case that we're arguing about now. We're not going to give you an in-depth illustration because we would have to look at lots and lots of cases and we don't have time. So instead, we're going to look at what happened to tradition.
Oh, there it is.
There it is, tradition, yes. I don't need to say a lot, I already have, but societies develop over time and they develop common understandings. So what is dishonesty? There is a feeling in the culture and in the society in Great Britain about what we mean by dishonesty. What's honest and what's dishonest, right? People always say that there is a big sense, that there's a great sense of fair play in this country. Well, what does that mean? Over time, we accept certain behaviors as honest and others as not honest. So we look at that tradition. And finally, policy, which I've mentioned very briefly before. Why do we make it so difficult to convict someone of theft? Is that because it's really easy to pick up property that belongs to somebody else? You might do it accidentally, you might do it mistakenly, you might do it under a false impression. So we're going to make it a difficult thing to do. However, we are going to enforce it because our policy is to make people's ownership secure, so they know what they own and they know they can do something with that property, like sell it or invest it, something like that. So those are our 5 basic kinds.
And in terms of attacking those 5 types of legal arguments, as Karen mentioned there, you do tend to use all of the 5 arguments when you are putting forward a case, a particular point of view. And this table here, I mean, I'm not going to go through it in any great detail, but this table here sort of illustrates how it is you might attack each line of legal argument. So, for example, you could argue in relation to textual that there are what's called canons of construction apply. So there are rules of constructing a piece of legislation which might apply. And I mentioned that one now because it might come into play in a few moments' time. Okay, so we're going to take those 5 legal arguments and we're going to try and use them in a practical way in the form of an argument. So in order to do that, we need to make up a story. So we've made up a story and we're going to imagine that the year is 2021, which isn't far away. And hooray, hurrah, huzzah, there is a vaccine for COVID-19. And as a result of that, the government wished to immunise everybody. It's a mandatory immunisation programme. They want to immunise the adult and child population of the United Kingdom. And of course, they will need to make a law in order to do so. And here is an example. Here is one we have made up. So this is all made up. Don't worry, it hasn't come in yet. Probably won't come in, but we've made it up. And this act says every act of parliament will always have a little preamble at the top of it. And this one says that this is an act to make provision for free and mandatory vaccination against coronavirus for the adult and child population of the UK and for connected purposes. Right, so that's what it's for. And then within the act, there are certain powers. And again, we've made all this up. We've drafted this. And if the government want to borrow it, they're going to have to pay me for it. So here is one power. It's the power that's given to the public health officer. So this is a power to direct or remove a person to a place specified for the purposes of getting immunised. So what might happen is the public health officer would probably, if this was a real situation, you'd probably get a letter in the post. And the public health office will send letters to everybody in the post and say, right, on this day, at this time, you've got to go to your local hospital or your local GP surgery, and you've got to get an injection. And that is the power. This is the section that gives the public health officer the power to do that. Further, it says that if the public health officer wants to, they could ask a police constable to remove a person to a specific place. In other words, force them there in order to get immunised. Now, where a public health officer exercises any of the powers within A, B, and C that you see on the screen in front of you, the officer must explain the reason why they're directing or removing them, and they must also tell the person that it is an offence in the case where a person is directed to fail without reasonable excuse to comply with the direction. Let me move on to section 5. This now deals, let's imagine the situation, you've been sent your letter and so you do go to the local hospital to be immunised. This section now tells us what the public health officer can demand when you get there. So it says that a public health officer may require you to remain there for up to 48 hours. The public health officer may require you to remain there and they must give a reason why they want you to stay there for a longer period, and also that's an offence if you fail to remain there and comply with the request. And this is the key one, subsection 3. A public health officer may require the person to be immunised by whatever means reasonably necessary and impose other requirements on the person. So that could be, for example, what is your medical history? We need to know, because we need to know if you're allergic to anything that's contained in the vaccine, and also perhaps to provide a blood sample. So those things are envisaged within the Act. And then we have the sting in the tail is where someone fails to comply with the direction of the public health officer or a constable. And in this particular section, it says that if you fail to comply without a reasonable excuse, then you will commit an offence. And the section goes on to define a reasonable excuse. It says, without prejudice to the generality of what a reasonable excuse is, it includes medical grounds or religious reasons. And the penalty is a fine or 6 months imprisonment. So no jury trial for you. This is a magistrate's court matter, and you could be sentenced or imprisoned for up to 6 months. So there's our pretend legislation. And now we have our pretend defendant. Here is Lydia, head of the best law school in England, but of course we would say that. And in our made up story, she's refused to get the mandatory vaccination as required by the section. She was prosecuted in the magistrate's court And she argued that she had a reasonable excuse, namely that she's terrified of the side effects of the vaccine. And in any event, on social grounds, she is a conscientious objector to this mandatory vaccination as a matter of principle. While the magistrates did not buy her reasonable excuses, they convicted her and sentenced her to 6 months suspended prison sentence, and she now appeals on a matter of law by way of case stated to the High Court. So that's where we are now. We're in the High Court and we're going to have an argument. Miss Widess represents the appellant, represents Lydia, and I will represent the Crown, the respondent. So we're going to take each of those 5 legal arguments, textual first, and try and argue about this particular case. So Karen, would you like to start on behalf of the appellant? What textual arguments do you have in relation to this legislation?
Thank you. The appellant would like to assert that under the language of the statute, she's been wrongfully convicted because she does have a reasonable excuse. If you look at the section about excuse, which is section 20 sub 2, if you wouldn't mind.
Oh, yes, indeed.
Thanks.
There we go.
There we go. So if we look at section 20 sub 2, it says a reasonable excuse includes medical grounds or religious grounds. What it doesn't say is a reasonable excuse is defined as only medical grounds or religious grounds. There are 2 things here. Number 1, this does not include text that is exhaustive. And we say that the legislature, had they wanted to make this the only 2 reasons that someone could put forward as a reasonable excuse, they would have said so. They would have used different language. Instead, they gave some examples. It includes. But beyond that, we can look at what do we mean by medical grounds. It's not defined here. Therefore, it is reasonable, it's a reasonable excuse to include the fear of needles as a medical ground. It could be both a medical and a psychological ground, which is in fact medical. If she's a conscientious objector, is that not, that could be tantamount to a religious ground. In this country, you don't need to be a part of a specific religious denomination in order to claim reasons of conscience. So she's saying that she objects to the mandatory nature of the statute, and that therefore her excuse is that it goes against her conscience and therefore she's refusing. So we would say that according to the exact text of the statute, she does not meet the definition because she is excused under this section. She has a reasonable excuse under the section.
Well, on behalf of the Crown, we would argue that the text does not define reasonable excuse, and so we have to look at rules of construction to decide what reasonable excuse possibly is. And when looking at a pure textual analysis, we can see that Parliament envisaged medical or religious grounds. And what we need to do is look at closely what Lydia is saying. She's basically saying, I don't want to be vaccinated because I don't believe in it. Well, if that's the case, then everybody would be able to rely on that ground. And we would argue that that is not the purpose of the text. We would argue that in order to be a reasonable excuse on textual grounds, the excuse needs to be quasi-medical. So you mentioned there that there is a fear of need. Could there be a fear of needles? Would that be a medical ground? Well, textually, the Crown would say that possibly could be, because there are psychological reasons as to why people don't like needles, provided there was the evidence. And it's clear here, Lydia's just saying, I don't want it, which is not the same thing. So you need to look at, and there's a couple of legal principles, which I'm just going to quickly, very briefly mention of construction. Firstly, there is the rule that's called expresso unius est alterius, which is to say one thing is to exclude all others. The fact that Parliament has specifically said these 2 things means that they've practically excluded all others. So that's one argument. The second one is look at the company it keeps. If you want to use a reasonable excuse, then you should use the company, look at the company it keeps, and the company it keeps here is simply medical or religious, and again, it doesn't come into it. So I'm afraid, on a pure textual argument, this excuse doesn't count. So that's our argument on behalf of the Crown on text. Let's now look at what you think as the audience. Could you please now get your phones out and vote just on that one argument, about textual analysis? Do you think the text does envisage this to be a reasonable excuse or not? So get your QR codes out now and let's have a look at what you think. So we'll give you a couple of seconds to vote. All you've got to do is hopefully hold it up to the phone. Votes are coming in now. Excellent. Yeah, coming in now, thick and fast. Keep going, keep voting, people. Let's go, go, go. Reasonable excuse, textual. Is there anything in the text that says what Lydia is saying is a reasonable excuse? Looking at the text, is it medical? I'm going to give you 5, 4, 3, 2, 1. And here we go. So the vote is in. Let's have a look at the results, if we may. There we go. Ooh, 52.6% on behalf of the Crown and 47.4% on behalf of the appellant. So very close indeed, but I win that one. Excellent. Let's keep that up. Karen, could you now take us through to intent? What do you think of the intent argument? What would you like to argue in relation to that?
Right, we don't really need it up. I would say that the legislature has clearly intended that exemptions from government compulsion be permitted and supplied an illustrative, although not conclusive list. UK citizens who have reached adulthood are allowed to make their own decision about whether to be vaccinated or not. And in fact, vaccinations used to be mandatory in the 19th century for various things. In 1907, the Vaccination Act was adopted by Parliament, and it eliminated compulsory vaccination and allowed for a claim of conscientious objection as a reasonable excuse. Now, this is 1907. Even after the Spanish flu pandemic of 1918, where something like 5% of the world population were killed, even with those sort of drastic circumstances, Parliament did not change this ruling of the Vaccination Act. And in fact, that Vaccination Act is still valid today. And what it says is that mandatory vaccination, it cannot be compelled if you have a reasonable excuse, and then in fact, being a conscientious objector is a reasonable excuse, and there's no indication that Parliament intended to change that in today's circumstances.
What my learned friend has argued, quite rightly, is pointed to an old piece of legislation back in 1907 that dealt with vaccinations and indicated that there was a reasonable excuse of a conscientious objector. That was written in to the legislation, and that was the intent of the legislation back in 1907. What my learned friend did not refer to was the fact that previously, in 1853, there was a Vaccination Act that came in first to deal with smallpox, which was a terrible pandemic, was killing children left, right and centre. And so they made it mandatory that everyone had to be vaccinated in relation to smallpox. As time then went on and the pandemic changed, by 1907, they could relax the rules, not make it mandatory, and extend the categories of reasonable excuse. It's a bit like lockdown, isn't it? As the pandemic gets controlled, the lockdown gets relaxed. That's how government works. That's the approach that government can take. Here, in this particular legislation, the intent as we discussed, is clear. The intent is clear in this particular preamble. They definitely want everyone given free vaccination because this is one of the biggest threats seen in this century so far. So it's clear from the intention of Parliament. They've made a very narrow category of exceptions here. Yes, okay, the court has a bit of a discretion to look at reasonable excuse, but they haven't been as broad as they have been in the past because the intention is clear. So that's the two arguments. Again, please vote. Do you think that Karen has won the intent argument, or do you think I have won the intent argument? Vote again now. So do you think that it was Parliament's intention to make this mandatory and that reasonable excuse be narrowly confined or more broadly confined, as Karen argues? So again, the vote's coming in now, thick and fast. Here we go. Yeah, quite a few people voting now. Yeah, coming in. Keep going, keep going, keep going, keep going. Get that scan. 5, 4, 3, 2, and 1. Here we go. Here's the votes, results coming in now, Karen, hopefully, if it comes. There we go. 57.9% this time say the Crown, and 42.1% say the appellant on this occasion. Karen, next one. So we're going to miss precedent, aren't we? Because we haven't got time to go through case law because that would take far too long. We have to refer to judgments and so on. So we're going to move on to tradition, please. So we have the argument on tradition.
Yes. And so as I was mentioning earlier, the law in the UK has evolved gradually and organically over time, and we have certain traditions about what we consider to be correct actions of the legislature and correct restrictions on adult behavior. So here what I would like to argue is that we have a long tradition. It goes back to the Magna Carta and has been built on ever since, of empowering the individual to make a personal decision regarding their personal and family life. And the government is subject to and restrained by that same law, which means it must respect that freedom of choice. And so as a matter of tradition, the appellant has the right to refuse to comply with government coercion when it goes against his or her conscience and beliefs. This is not the same thing as just saying people can do whatever they want if they don't want to comply with the statute. It's very different to say, I choose not to be vaccinated because of legitimate concerns about the conduct of my personal life, which affects
we lost
statute, and I'm going to steal everybody's property. Further, I would say that our tradition is that ministries and governments are limited as to what they can actually legislate in, and to encroach in this area of traditional freedom of choice for adults is a step too far. And this part of the statute, the compulsory nature, should not be permitted.
Okay, I would, very, very brief argument. It's a very weak argument that's been put forward referring to the Magna Carta when freedoms, that was about freedoms of the monarchy versus the citizen. We're talking here about when there is a health pandemic. Are there examples of where the government have had to step in order to protect the general population? Yes, there are many examples where tradition says the government's role is to protect the citizens of the country. War being one of them, and the second being public health. They did it before with smallpox in the 1800s. They did it in 1954 when there was a huge epidemic with cholera. They closed down public water pumps in order to help with that. And it's clear with the Coronavirus Act of 2000 that the government has been prepared to limit people's lives in order to protect the greater good. So tradition says, yes, we have personal freedoms, but at times of crises, you must also protect other citizens. So again, ladies and gentlemen, now it's time to vote. What do you think about tradition? Do you think tradition is on the side of the appellant or on the side of the Crown, the respondent? It's coming in, keep going. 5, 4, 3, 2, and 1. And here comes the votes now. Ooh. Sometimes brevity in an argument helps, I think, Karen. There you go. And finally, the last one, policy. Any arguments on policy, please?
Yes, I would look at, if you would, the preamble to the statute.
Okay, so I'm going to go the wrong way. There we go. Preamble coming up. There we go. Preamble.
There we go. So if you see the intent here and is basically to make a provision for free and mandatory vaccination. Okay, this reflects on what the government's policy is. It makes provision for this. However, what it cannot do by making this is go against the overriding policy, which is respecting individual human rights for its citizens and not overstepping its bounds. Public health is a legitimate concern of the government, and therefore, from a policy point of view, it can take necessary actions. However, under the European Convention of Human Rights, those actions are strictly limited to those that are necessary in a democratic society in the interest of public safety, which I assume is what the government's argument is. What I would say is that there is the use of that word necessary reflects the policy of the government in order to protect the public health while not impinging on the human rights that a person has under the European Convention. Does the policy aim of protecting public health, is it necessary that every single person in the United Kingdom be vaccinated, regardless of various feelings against it, including medical reasons, formal religious reasons, but also reasons of conscience that believe that being vaccinated against their will actually impinge on their rights. And I would say the policy of the United Kingdom has never been to infringe on those treaty agreements and overwhelming powers.
Thank you. I would argue on behalf of the government that yes, that is the policy. It's a policy that is within the Convention of Human Rights under a number of articles. Not every single right is an absolute right. Most rights are qualified. So take, for example, the right to family life under Article 8. You have the right to privacy and the right to private life. However, it's qualified when it comes to matters of security and prevention of crime and so on. So the same applies to the health of the nation, the economic well-being of the nation. And if we were to accept the appellant's argument here, it would mean that one person is more important than the many. And to quote the words of Spock, needs of the many outweigh the needs of the few. And in these circumstances, I would argue that the European Convention, the European Court of Human Rights would side with the government here and say that it cannot be a reasonable excuse for people to say no just because they don't agree with it. As a matter of policy, the country has decided it needs to vaccinate everybody, and therefore everybody has their duty to do so, and therefore the many outweigh the needs of the few. So that's what I would argue in relation to policy. So there we have it, ladies and gentlemen. We've had 4 tranches of legal argument. Obviously, you now need to put all those together and come to your final decision. Overall, who wins? Does the respondent, the appellant win, or does the respondent? Vote now. Votes are coming in thick and fast. Karen, how do you think it went, Karen? Do you think you're going to win?
Well, I actually think I should have won the second argument on intent.
Oh, okay.
But we argued it as precedent because that 1907 statute is still in force today, which outlaws mandatory vaccination.
But in our imaginary world, we'd assume, wouldn't we, in our imaginary world next year, if this were to come in as a matter of correct legislative practice, they would, of course, have to essentially halt the 1907 Act. They'd have to amend the 1907 Act. That's what they'd have to do.
But what I was also going to point out is that the penalties under this act that we've been arguing, right, the 2021 Vaccines Act, the penalties are only fine and prison. There is no mandatory vaccination as part of the remedy. So even when my client loses, which I have a feeling she will, the state still cannot hold her down by force and vaccinate her under this statute.
But they could prosecute her again.
They could keep her in jail forever under contempt.
Keep prosecuting her. Yeah. And you know, other countries, having looked at this, other countries have come up with other ways of making mandatory vaccination through the back door. So in Australia, for example, you can't put your child into a state nursery or a state school unless they've been vaccinated, which is really mandatory vaccination through the back door, isn't it, really? Let's see how the votes came in.
Okay.
Oh, nearly 75% said the Crown wins, and 25% or 26.1%, we'll give you your 1.1%, say that it's the appellant. So I'm afraid Lydia will have to keep her a conviction, and if she doesn't get vaccinated again, then I think she should be prosecuted. Yes, do we agree? Everyone in the chat, if you agree with that, then say yes, she should be prosecuted again. Okay, yeah, some take-home points before we wrap up. We've got a couple of minutes just to wrap up. A legal argument is pointless if it's not to be persuasive, and so 4 take-home points are these. 1, as we did today, invoke more than one type of legal argument. Obviously, it's more persuasive if you can weave together the different legal arguments. 2, carefully consider the order in which you present your legal arguments, because Karen might have presented actually a different argument first. She might have gone under policy first, whereas the Crown might have relied on the text first. So each side can decide the order in which they take it. Thirdly, law is not a science, as we said earlier. The goal is not to describe the state of affairs, but to persuade others to adopt your view of what the law is. It's a dramatic production based on conflict. And number 4, always scrutinise all of the legal arguments and try and predict what your opponent's going to say, and look for the weak points of your own argument as well as theirs. So they're the 4 rules I would take home in order to deal with your usual run-of-the-mill legal argument. So before we go though, there's a quick plea for help, Karen, isn't there?
Right. So many of you may have participated in more than one of our summer law webinars, and there's another one to go in 2 weeks' time. We are evaluating how we did. This was our first try at this. So we're looking for participant volunteers. If you have a few minutes to talk to me about what you thought about the whole program or just today's webinar, if you saw several of them, to give us some comments, what you thought went well, what you thought didn't work so well, how you would improve it. So there's my email address at the bottom of the screen. Please drop me a line, right? Tell me you were a participant and you're happy to talk to me for a few minutes. We can do it both in writing or over Zoom or some kind of other chat platform. And we would really appreciate your help in this, because we're only going to try to make this better as we go. So really, thank you.
And that's about it then, isn't it? I think that we better go, because our time for our legal argument has in fact now gone, and it's time just to say goodbye. So thank you very much for listening, and we hope that you found something out of it, and we will hopefully see you again at our next webinar, or at university studying law. So goodbye and enjoy the rest of your summer.
Thank you.